Okay, it is now 3 p.m. And so we're going to begin the presentation. Today's topic, our webcast, is Truth and Myths of Copyrights and Compliance. For those of you just joining, we are recording this session to the best of our ability. We have spoke with GoToMeeting. We believe we've figured it all out. And so we are going to be putting up a recording, hopefully we'll both the video and the audio, for members of the Licensed Logic Institute. If you'd like to find out more information on the Licensed Logic Institute, we will be having, we have a lot of benefits, including webcasts we're going to be doing for members only. We're also going to be having some more invited webcasts as well as we're going to be having knowledge nugget courses, mini courses, for folks, white papers, and a lot of other. We're trying to build a community that's not only serving the software manager, compliance manager, procurement buyer, but also, just like in today's course, we're going to be focusing also on folks related dealing with copyrights, subscriptions, and that is, you know, in today's market, when you're a software manager, you might have Microsoft 360. That could be an example of subscription. But within your environment, you also might have Salesforce. It's another example of subscription. So I'm going to be touching base about that. And then within your environment, you might have Factiva or LexisNexis, all sorts of databases your organization needs to be aware of, especially in terms of copyrights and compliance. My name is Adam Ayer. I'm going to give a brief, well, not in this course, I'm going to be going a little bit into kind of my background so that you have an understanding of where I'm coming from on my viewpoints of the copyright law, of its myths, of its truths, and I'm going to be addressing those things throughout the day. First off, I'm not an attorney. Though I'm married to one, though my brother's one, I, fortunately or unfortunately, am not an attorney. I have worked with the FBI. I'm one of the few people in the world that have put multiple people in jail, and I'm not an FBI agent related to or the case started with the copyright law. That's right, folks. There's not too many people in the world that actually go to jail for copyright infringement, but I happen to be fortunate when it was really high on the FBI's priority list to work with the FBI and help put some of those people in jail, actually in jail. There just isn't too many of these folks that actually go to jail here in the U.S. One of the reasons is a lot of the folks that commit infringement of copyrighted works, whether that be software, movies, music, e-books, etc., these people reside all over the world and are very good at hiding themselves as well. I have worked with software cops, the SIA, whether that be in the CSM, which they still have some copyright ownership along with Licensed Logic, or whether that be back in the day when I used to work with them on cases themselves. I have worked with some of the software cops. I've also sat at tables in meetings with the FBI and with the BSA, the Business Software Alliance. And I still maintain relationships in some way, shape, or form with some of the software cops, quote-unquote software cops, that are out there in the field. So, you know, my experiences, I've been on that side of the fence, and I've seen what cases they tend to take on, they being anti-piracy organizations that represent the likes of Microsoft, Adobe, you know, Autodesk, and many other software publishers are out there. I've seen what cases they're given. I've also seen what cases that they're not approved to go after. In addition, I've helped end users. End users fight against the SIA, fight against the software cops, the BSA, even some of the publishers themselves. So I've kind of seen all sides. I know the tactics of these software cops, or that shouldn't be. That should be quote unquote cops, because they're not software cops. And I'll briefly go into these organizations just in discussion. So I've worked on both sides of the fence. Another note is I am the only non-attorney to sit on the Special Libraries Association Copyright Experts Panel. And we give a quarterly review of what's going on in the copyright industry, and that's the Special Libraries Association. For those of you, and most of you here today are on the IT side, attending today's side. However, with the cloud coming into our environment, you will be or should be aware of if your organization has any librarians or folks in charge of buying and distributing content within your organization, because these people share a lot of the same responsibilities that you do when it comes to dealing with licenses and copyrights. So one of the first things that I want to do is kind of establish what are some examples of works related to copyright infringement, beyond, of course, the obvious, which is most of you here, software. I, of course, have a loving relationship with the software license agreement. Hence, License Logic is the institute that I created, and it's license agreements in general. We're going to be going over how they relate to the copyright law as well. But what are examples of works related to copyright infringement? Well, we got the obvious one, right? Software, right? Books and e-books, electronic books, movies, music, plays, any type of digital plays, like that too. It plays that kind of out of the woodwork there. But if you go and watch a play at a stage and it's being recorded, well, there's copyrights on both sides. There's the folks recording the people giving the play. There's the playwright themselves, and then there's the recorder as well. So there is a number of different works involved, and who owns what. Well, that should be predetermined in the perfect world. But one thing that we have to realize as an organization is that the license agreements typically go hand in hand with copyright law. Notice I have the note, some explanation needed here. Well, the copyright law essentially in Title 17 of the U.S. Code states that a work or the copyright holder can distribute the work any way that they see fit. So what does that mean? That means that if they want to distribute via any license agreement, whether it be network or you're allowed to install it on one device, etc., they can do so, and they give you these terms inside the license agreement. It basically enforces the license agreement or gives teeth to the license agreement itself. The copyright law does, because of a provision that basically says, hey, the copyright holder is allowed to distribute how they want their copyrighted work. And we're going to apply it to the software. You can apply it to ebooks now. You can apply it to movies and music, any sort of digital work. A digital work could be an icon that your graphics department uses, and they've got works for a font license, etc. It's up to the creator of that work and up to them to put in a license agreement to go with it. Now, where does this, we're going to be getting into the truths in this, but some things that we've got to start thinking about are subscriptions, or now the cloud-based environment, where essentially our end users, whether it's Adobe Creative Cloud, whether it's Microsoft Office 360, 365, 360, whatever, right off the top of my head, I can't think of it. I'm sure someone can correct me. But we've got these subscriptions. We also have Factiva, LexisNexis, even usernames, passwords, anything with a username, password, anything in which we as the end user, we go into the cloud and we go to the publisher's authorized environment and we access this product, whether it be databases, software, or whatever. In terms of kind of copyright or copyright infringement, one thing that I wanted to point out at some point is we have to be aware of that sharing of usernames and passwords. This is going to be getting into some very dicey situations, because immediately once we share, the publisher or the copyright holder might know immediately once one of our end users shares a username and password, because we're logging into their system. So that's kind of one of the things I want to make sure that we're going to touch base with at the beginning. We're also going to circle back around towards the end as well. So we have all these different works in our environment. I'm making some assumptions. I'm making some assumptions that if you've got if you've signed up for one of our webcasts, then most likely hey, you know what I just said. You know that you shouldn't share usernames and passwords unless, of course, the license agreement allows you to do so. That should be kind of inherent knowledge. So I'm making some assumptions here. You shouldn't install multiple copies of a piece of software or or an ebook or anything unless the license agreement allows you to do so. Put it into a network environment unless, of course, the license agreement allows you to do so. So with these assumptions being made, I also want to kind of go over some of the truths of copyrights and compliance. One is, in the U.S., statutory damages can get quite high, up to $150,000 per work infringed. We're going to be getting into what that per work infringed is. I also want to point out, that willful infringement must be applicable to reach that statutory damages of $150,000 per work infringed. You oftentimes, and this kind of gets into the truth and the myth in one crossroads, because you oftentimes hear from the SAM consultant, from the SAM vendor, from anyone that's wanting your organization to comply, to buy their tool, they're going to give you the kind of the scary aspects. And so, I want to make sure you're aware of all the aspects. Yes, if it is deemed willful, they can get as high as $150,000 per work infringed. Now, what does work mean? Well, a work's going to be argued in court. What's considered a work? Is it Adobe Photoshop, version 6 or version 4, across 10 computers? Is that 10 different works? Well, if it's 4.1 on one machine and 4.0 on another machine and 4.2 on another machine and 4.4 on another machine, and they could argue in the courts that each of those, even though it was an update, that all of them are pirated, and all of them, there's a significant difference between 4.0 and 4.4, and they're all pirated. And if they could prove to a judge and jury, then yes, maybe they could get each work, and they registered each work with the copyright law. In other words, 4.0, 4.1, 4.2, 4.4, and they register with the copyright law. There's a lot of moving parts here, folks. And I want to get into, this is kind of where my experience, might lend some knowledge or some experience here, because there's a lot of moving parts. And so what is considered a work? Well, generally it's the title of this in terms when we get into software. When we get into ebooks, and we're going to be getting into ebooks, or a journal, that's what more specifically we're going to be getting into, a journal being passed around in office. Then it gets scary because journals are usually weekly or monthly or some regular basis. Then it gets a little bit more scary, I guess. I don't know what the term is, but a little bit the infringement can happen higher. So yes, damages can get quite high, but at the end of the day, a judge and jury is going to decide the final outcome. So this is what's interesting, is that sometimes you see in copyright cases, and you've seen this in the music industry, related to the music industry has gone after, in general, the RIAA, and some of the music publishers have gone after individuals that pirate, their songs and whatnot. And people say, well, boy, they shouldn't go after individuals. And this gets into that copyright and myth, that kind of blend there. Well, music industry, unfortunately, one of the provisions, in order for a company or a business to be associated with a copyright infringement, it has to be argued that the infringement was used for business purposes. Well, the music industry has a hard time making that argument, even if, or it's a harder time, I don't know it's 100%, but it's a harder time for a music industry to go after anyone for, pirating Britney Spears' song as a business, unless, of course, the business was, broadcasting Britney Spears' song across the hallways. So a judge and jury, what I've seen, and I kind of went off on a little tangent there, what I've seen is sometimes I see the award given to the defendant or to the plaintiff, a statutory amount of, let's say, I think it was like $2 million, and I've seen a judge then say, no, that's too high, and they lowered it down to $50,000 against the defendant. So, one of the cases that we, as most of us are on the software side, have to realize is that, unfortunately, there are very few cases that directly relate to in-house infringement matters, especially on the software side. And what I mean by in-house infringement matters, yes, there are some cases that I've seen Microsoft go after in the courts, that I've seen Autodesk go after in the courts, that I've seen Adobe go after in the courts, but most of those are cases related to direct infringement. In other words, and what I mean, I guess not direct, but more the sale of software piracy, kind of the individual or a group of individuals selling pirated works, rather than in-house software infringement, because most of those matters get handled via an audit, which we're going to be getting into. Threats of audits are present. We're seeing a big kind of evolution of, where software audits used to occur 4 or 5 years ago, BSA, SIA. Now the publisher is taking on that, partnerships with small SAM consultants to large SAM consultants, the Deloitte, the KPMGs, to smaller shops that are, 2, 3, 4, 5 people doing SAM consultancy work on the behalf of Microsoft or Adobe, etc. So it's an interesting shift in terms of compliance. Compliance is now necessarily away from copyright infringement to more license compliance, and so they use possibly the copyright as kind of, hey, we could in theory take you to court, but we really haven't taken too many people to court. Those that we have are cases related to folks that actually sell or distribute the software. But instead, we're going to go after it and kind of enforce our contract, our license agreement. And so that is kind of a very important thing to make note of internally as an organization. Just to kind of make sure, we are aware of of how the compliance is going to occur. Now, I mentioned willful penalties. And yes, willful penalties can get quite high, up to $150,000 per title infringed, per work infringed. Non-willful penalties may apply as well. And I don't want to say statutory damages are relatively low. And this is where I feel that as an organization, you never get out of jail free per se, but this is an action item. If you are doing your best in terms of enforcing policies internally, and you can prove that, and that's what I'm talking about when I get into everyone that's ever taken a class from me in the last 5-6 years, or any one of my instructors knows or should know AE squared, and that's awareness, education, and enforcement. And what I mean by that, you have to have that enforcement of your policies and your procedures. If you have that and you can prove that in the court of law, then you have a shot at least, because there aren't too many cases out there, you have a shot at least to possibly sway the jury to say, listen, this wasn't willful, this is non-willful. This was an end user who pirated for his group. As soon as we found out that he or she was doing it, we fired them, we've removed them from our organization. But yes, at one time they pirated this software. I guess they're trying to save on their budget. We later correct it. Yes, the publisher is taking us to court, but as you can see, we took corrective action internally. Now we're looking at possibly non-willful infringement penalties may apply. It's up to the judge and jury. You've got to sway them to that. But instead of that up to $150,000, now you're looking at $750 all the way up to $30,000 per work infringed. It's a much different threshold. You know, the threshold is much different. Now, if it is considered willful infringement, yeah, criminal penalties may apply. It is extraordinarily rare. I've been there. I've actually, seen one of the guys. I actually went to the court case here in Washington, D.C., saw one of the guys that I was helping the FBI with go to jail. So it's extraordinarily rare for criminal penalties to apply. So in terms of copyright infringement, and in terms of compliance and kind of things to be aware of, I want you to be aware of willful penalties and non-willful penalties, because I think that helps an organization, you know, say, listen, let's try to do our best ethically, morally, obviously obligatory, you know, obligation-wise to the contracts that you have, to do your best, take corrective action, because if you are in a situation where, listen, some of you are from organizations that might have 3,000, 5,000, 70,000. I think there's one in here that's around possibly even more than 100,000 employees. Keeping track of what goes on with one guy's budget in a department that's sitting 5 states away from you, and you don't know that that guy is, you know, trying to save money and go within his budget, and he's buying CAD software illegally, you know, and then you find out about it, and you take corrective action, you enforce the penalties internally. You know, it is tough internally. So you have to at least try to lower your liability and be okay to say, listen, we've taken that corrective action. Hopefully we can at least try to say, you know, this wasn't willful as the organization, this is a one-off case, and try to get a judge and jury to go with you on that. Threats of audits in today's world are the largest factor, I would say, in terms of compliance. We're finding that most, if not all, the major vendors, IBM, Microsoft, Adobe, Autodesk, Oracle, etc., are using the audit clause more so today than I would argue 4 or 5 years ago. They're using the audit clause, they're sending in, and sometimes they kind of guise it. they mask it a little bit in the sense that they call it, an assessment or something to that effect, when at the end of the day, it's an audit. And that is more of a compliance effort for them to get the organization to comply with their licenses. So, you need to be aware of the fact that the audit is how, if it's a publisher, how most likely they're going to come in and get you to be compliant, not necessarily with the threat of copyrights. But that's why I have that question. Where's the teeth? If there are very few copyright cases that we can point to, because I think it is important for both sides, both the publishers, the copyright owners, and the end users, to have cases to point to, because I think one of the biggest hurdles internally within any organization is selling upper management on the fact that, hey, we need to manage our licenses. We need to do software asset management. We need to do software license management. We need to become software compliant. Because, and they say, okay, but what's the liabilities here? And if you're pointing to, audits that, or settlements that, not all these publishers publish any settlements that they do. If there's no case, the thing that's nice about a copyright case is it becomes public knowledge. Then you can point to a particular case. Now I have one case of importance that we can all relate to, no matter if you're doing software or if you're doing content licenses, that we're going to be getting into. But I think it behooves, though the software companies are getting into doing these audits, I think it behooves them for at least one or two of these publishers to go to court against a gregarious pirater. I'm not saying against one of you guys. I think if anyone attends here, they're trying. There are plenty of folks that are not trying to become compliant or to manage their software or to manage their content agreements or whatever agreements that they have in place, movies internally, music internally, etc., graphics, libraries. I think it behooves them, because then the end user can point to more copyrighted cases. Now, one of the cases that we get into, and we're going to be announcing our Certified Copyright and License Manager certification that'll be out coming up, is we go into Lauer's Report versus Legg Mason. And very simply, I worked with the attorney that represented Lauer's Reports, or one of the attorneys that represented Lauer's Reports, Scott Bain, and I worked with him for a period of time, helped develop content together, and I asked him very intensely on Lauer's Report versus Legg Mason. And some of you have heard me say this, but I think it's a very important case that everybody needs to be aware of. And that is, you need to be aware of usernames, passwords, and by the way, if you have any questions, we will try to address these at the end. I know when we're getting into compliance, we'll try to address it, so I'm allotting some time at the end of this. But Lauer's Report versus Legg Mason, it's simply a case in which a simple subscription went wrong. And the gist of it is this: Lauer's Report is, at the time, this is in the early 2000s, final settlements 2005. I know that's almost a decade old, but it's one of the cases we can point to in terms of statutory damages. And it's a simple subscription gone wrong. And this is a case in which Lauer's Report is a 10-man shop. This is a shop in which they produce a content journal. It's a financial journal, newsletter, and it gets sent out to the financial institutions. Boy, you're thinking, well, what does this have to do with software? Well, this is one of the things that you guys need to be aware of, those of you managing software, is that, hey, we might have these journals internally. We might have professional journals internally within our sales force, etc. But not only that, this is a statutory damages case. The same statutory damages that apply to software apply to, like I went into before, apply to journals, content databases, etc. And here it is, a simple subscription gone wrong. So one day, it's a 10-man shop. They get a call for a volume agreement. And what happened was, whenever a volume agreement comes to the owner of Lowry's report, the sales guy forwards it on to the owner himself. And the owner then keeps track of all the volume agreements. So the one-off agreements, kind of the smaller agreements, but if it's a large purchase, the owner likes to know, who it is, get to know the client, and cater to the client, make a sale. And what happened was, they got a call, went to the owner, and the owner said, the call was, hey, I'd like to purchase a volume agreement like we had at my old enterprise. And the owner of Lowry's report said, okay, where did you used to work? Let me look up the volume agreement. And he said, well, I used to work at Legg Mason. He said, okay, give me a second here, and let me look it up. I'm sorry, there's no agreement, and that doesn't come to mind either. There's no volume agreement that we have. And so, this is something that, here it is, the owner handles the volume agreements. He realizes, well, wait a minute here. You're saying at Legg Mason you guys had a volume agreement? And the person said, well, yeah, everybody had your Lowry's report forwarded to their desk every Wednesday, or whenever it was, the regular time, forwarded to their email. And what happened was he said, you know what, Legg Mason never had a volume agreement with us, and he started a case, and he pursued it through the courts, and basically it was very, they were sharing usernames and passwords to actually forwarding on the newsletter for those. They even actually faxed it to one group. Legg Mason faxed the newsletters at one point instead of email or anything. I can't remember why that was, but upon further investigation they found so many numerous reports. Now, how do you get to 20 million? Well, you can't get to 20 million if it's nearly $150,000 per title infringed. Well, it's I don't think it's possible. Basically, one of the things that when we get into statutory damages, notice it says up to $150,000 per work infringed. This was a regular journal. I forget how periodic it was, if it was weekly or monthly. The plaintiffs were arguing that it was like 400 works infringed, and somehow the jury came back that it was around 200 works infringed. The exact dollar amount that was awarded to the plaintiff, which was Lowry's report, was $19,725,000. Now, this is something that we need to be aware of. Statutory damages, and how did they come up with this? Well, it was nearly $100,000 in work per work infringed. The jury has a lot of wiggle room in terms of, when it gets to willful infringement. Remember, the threshold starts then for willful at $30,000 up to $150,000. So this is where, we've got to realize where, the importance of managing copyrighted works, not only in terms of software, but we also have to realize, hey, wait a minute, do we have any professional journals? Now, what's interesting is that, let's think about this. Lowry's report, I mentioned 10-person shop. Legg Mason, that's several thousand employees. That's like David versus Goliath. That plays into it when it comes to the jury deciding the awards. Or let's go back to that music. You know, that was an individual I mentioned earlier where it was a $2 million lawsuit, music-wise. I mean, there was several of these cases. And then the judge lowered it down to like $50,000. You know, big industry, music industry against one lonely individual, which most likely probably couldn't even pay the $50,000 awarded to him. So, you know, all these different factors, and that sort of factors in as well as to sometimes why the software publishers don't necessarily always go after anyone for statutory damages. So it kind of plays into everything. Now, I want to get into, I said, the truths and the myths, right? The truths and the myths. One of the things, though, that we need to be aware of when we start to get into, you know, e-books or journals, professional journals, monthly subscriptions is, well, some of you are from universities or nonprofits, and your users say, well, yeah, but it's the fair use. I have the right to do X, Y, Z with this product. And you know what? There are some very complex issues. Scholarship purposes. If the work is used in the classroom, there could be some exemptions. But it's a fair use defense, and it's a kind of a potential myth. Notice it's not a fair use right, it's a fair use defense. So this, for businesses, this doesn't really apply, at least this potential slide. So just bear with me, this will be more informative, kind of hopefully interesting to know and to recognize. But the purpose and character of the use, you know, latest news, the dumb Starbucks. Okay, well, the purpose and character of use, if it's used for parody, scholarship purposes, then that is something that you can typically use that potential work. So trademark, Starbucks, I don't know if you guys saw this, LA County News, the comedian that started this dumb Starbucks shop that got closed down. I'm sure Starbucks themselves were probably going to have it closed down, but the LA County closed it down because they didn't have the health inspection and all the fees associated with it. Well, the guy is claiming that he's doing this underneath the purpose and character. He did it as a parody. So he's basically claiming the fair use right, and that he was using it for artistic purposes. And one of the things he's claiming is, you know, this is a fair use. This was a parody of Starbucks, and we were giving out something free. It had no potential effect upon the market, which we're going to get into. But it's a 4-factor test. It's not a fair use right. That's one thing to note. And it's a fair use defense. The nature of the copyrighted work, factual versus fiction. You know, if I'm at the corner of Speedway and Wilmot in Tucson, Arizona, I don't even know if those connect, but you know, and I see an accident happen, then and right across the street I see Cornelius see that same accident occur between a red car and a blue car. Well, we both could write up a story that goes in the newspaper and says red car hit the blue car and this accident occurred at this time of day and you know, at this cross streets. This is a factual event. These are facts. We're both probably going to write the same, pretty much very similar facts. I can't say he copyrighted my work or he copied my work or vice versa, most likely. You know, I mean, it's if versus fiction, if he wrote some play or story and I copied it or is very close to it, then he might have a case against me. The amount and substantiality of the use of the work. You know, notes on Nixon. Oh gosh. See, I need to and I apologize not knowing this. It was the memoirs of, I believe, the vice president to Nixon, as I recall. And basically his memoirs, this is a big case. The crux of the only reason or the main reason why people would buy his memoirs was because he was going to talk about Watergate. Well, someone got a hold of an early copy of the book, and they took out all of his notes, you know, his pages on the Nixon Watergate, and they summarized it, and they were producing it themselves. And they tried to claim it was a fair use. Well, they lost because it wasn't fair use. It wasn't the amount that they took, but it was the substantiality of the use. And then the effect upon the marketplace or the potential market. This is arguably the largest factor. So if someone copies work or uses a work without the proper authorization to do so, if it has an effect upon the potential market, then that's going to be one of the biggest issues. If it's going to take dollars away from the copyright holder, that's going to be the biggest issue. If any one of these factors is violated, then the defense is useless. Okay. Now, scholarship purposes, used in the classroom, a movie shown to students, and the movie, the students are going to talk about that movie, that's been decided as okay. But it's interesting, the copyright law, when you go through it, and actually the cases that go to court, you know, you've seen both sides of the fence kind of win. I mean, the nature, or the what was it, the Pretty Woman, Two Life Crew used the song Pretty Woman as the kind of the backdrop of one of their very derogatory songs that they did, a rap song. I don't know if you guys remember who Two Life Crew is. Maybe I'm predating you guys. I don't know. But basically, these guys were dirty rappers, and they made a very dirty song about Pretty Woman, and they used Roy Orbison's work. Well, Roy Orbison took them to court, and it was found that underneath the fair use defense, it was okay for them to use it. And there's a really, you know, sometimes the courts get it right or wrong. I mean, it kind of goes both ways, and sometimes that scares away copyright holders as well as what's the risk. They rather, so let's go into the compliance side. They rather take the compliance up via a contractual agreement, via an audit, and that's typically how they try to do that. Now, one of the things that I want to get out, many cases, that's kind of a myth. There are not many applicable cases that apply to in-house infringement. You know, we've got Lauer's report versus Lake Mason. There's a few more out there, but there's just not enough. All the big guys, you know, do they go to court? No, they don't all go to court to take people up. They typically settle cases before they actually go to court, before a judgment is made, and that's a very, very important difference than a settlement, by the way, because we're not finding out all the facts of the case. That's one of the things. You can read about the facts presented or the presented facts that occur in a case themselves. Autodesk is the exception, I would say, to the rule. They typically really, you know, you see them file with the court system quite a bit for how big Autodesk is as compared to some of the other guys that are out there. And they do have a very aggressive approach to anti-piracy. They also are very aggressive in terms of folks reselling their works up on eBay as well. And then a myth is all universities are exempt underneath copyright law. Hey, you know what? I mentioned scholarship purposes, the fair use defense, and then there's also some state sovereign immunity for universities, but that's a myth. I mean, you really have to, you know, get with your own in-house attorneys and really decide what your policy is going to be when you do have these arguments by your professor saying, hey, this is a fair use right. Get the awareness out there. You know, some actions to take are, you know, let's educate our staff on the infringement penalties, on these audits, because this is how compliance is coming in the door now. You know, hey, let's know about the infringement penalties. So let's know about, hey, if you want to debrief them on the fair use defense, you know, go for it. Let's know the liabilities to the best of our ability, whether that be liabilities in terms of the copyright law, in terms of what our liabilities are in terms of our license right. What do we have any audit clauses built in? Do we click I agree? to an agreement that we disagree with, or it has an audit clause in, how enforceable is it? Be cautious of threats, by the way. Be cautious of threats. I would argue that, we've seen click-through agreements be enforced, but the click-through agreement that has an audit clause in it, this is interesting. It hasn't been brought up to court yet. I believe there will be. From what I'm hearing, there could be a potential end users bringing the publisher to court over an audit clause, because if you are going to have an audit clause, typically it's like 30, 60, 90 days notice. You need to start to get those details about, and one of the things that we're going to get into in the conclusion here is get the details in those audit clauses, know what those details are. But get out the awareness internally. Let's make everybody aware of, what all the infringement purposes, damages are, the copyright damages are. Note to say, listen, we could go to court. There's not a lot of court cases out there per se, but there are a lot of more audits that occur today, whether you go to Gartner, whether you go to just type in audits, Microsoft audits, Adobe audits, etc. You're going to find more of the compliance is happening in the enforcement of the contract, of that license agreement itself. So let's get that awareness out there. Be smart. Look at your agreement. Think ahead in terms of planning. When we're saying, listen, we know we've got a volume agreement coming up. We have this prior audit clause in. Is 30 days enough notice? Probably not, realistically. How are they going to do the audit? Who's paying for the audit? What I say to people that take my classes if at all possible, you pay for the audit. You, the end user, pay for the audit, because then you control how that audit occurs, because there is no silver bullet discovery tool out there that it has 100% accuracy across every single title in the world. And because of that, you could have inaccuracies in the audit results that you want to correct before anything is agreed upon on any audit settlements. So think ahead in your planning when it comes to kind of audit clauses, because that's where compliance is going. I want to make sure everybody is aware of the copyright law and everybody do the right thing. Compliance does help organize. And if you organize, then you can start to see where your gaps are, where you might have over-purchased, potential ways to, next time you negotiate or not buy as many licenses, potential cost avoidance, cost savings, kind of the whole ideas and concepts built that software asset management is built around, software license management is built around. And so compliance does help organize as well. So be smart, look at your agreements, think ahead in terms of planning. Let's know the copyright law. Let's know what the penalties are. Let's know how folks are auditing. Let's also start to peek around and look at, do we have any professional journals in? What are all the different ways that people are sharing usernames and passwords? That doesn't only apply to, your software that you're getting. That applies to, hey, does someone have a New York Times subscription? Does someone have a subscription for this magazine, for that database? Are they sharing their usernames and password? Let's get ahead. Let's make sure everybody's aware so we can compliance help organize us internally. And then we can start to evaluate down the line, how can we get better licensing, etc. Okay, I wanted to leave some time to go over things. Okay, we got a question here. I don't know what you know about aid and abet in copyright infringement. To what extent would a third party be liable for copyright infringement if they're not the actual infringer? Okay, so if I'm assuming that aid and abet, are you stating that if someone were to buy counterfeit software online, via eBay or something. They didn't know that they were committing the piracy. Is that they call secondary, or what they call secondary liability? I assume that's what you mean. Is that correct? That if you were to buy counterfeit software you didn't know was counterfeit from a reseller at some point, and then later on you were held, or potentially, what's my liability for buying this illegal work? Is that correct? I'm going to make that assumption. That's I guess so, but I was actually thinking of a third party that pays for the infringer to do infringement. And where it's going. Well, okay, so I'm not exactly the scenario, and these get into kind of complex scenarios. So if they are aware of it, if it's willful, maybe the scenario is a person hires a consulting company and they tell the consulting company to install a bunch of illegal software, and the consultant says, well, you know what, you don't have enough licenses, and the client of the person paying the consultant's bill says, well, I want you to install it anyways. You know, who's held liable? I don't know if that's exactly, but we'll go with that example. Willful infringement is willful infringement, and that's where, you know, again, I wish I had more court cases to point to. We'll get into the eBay. There's a couple more examples of that in just a bit, but if it's deemed willful, if all parties knowingly know, the consultant, the I don't know if you call it the client or the employer of the consultant, know that the piracy is occurring, well, everybody's going to have some liability to some degree. Is it? And that's kind of up to a judge and jury to decide where does that to you know, if they are they aware of it, are they directed to do it? Everybody's going to have some liability. My guess is, in terms of civil-based infringement, if you're the publisher, you go after where the money is. So if the money is with the consultant, i.e. Deloitte, and maybe the client, then you go after both. If you know, if it's a smaller consultant and a large company, you're probably going to go after a large company. It's really up to, my guess is they're probably going to name everybody in the lawsuit because they can. If everybody was aware of it and there was direction and they still did it even though they knew it was wrong, because, you know, obviously consultant knows it's wrong, but he or she is doing it to get paid. Well, they still knew it was wrong, and, you know, like anything else, you know, if I get paid to go steal a car, well, you know, I still know it's wrong to steal a car. So I think the liability is for everybody. Now, let's get into the eBay. Let's say you buy something off of eBay. Again, if you're using it and unaware of it, there's still, you could at least argue non-willful infringement, but you're looking at $750 per work to $30,000 per work infringement. So I guess you could argue non-willful infringement, which is that whole gamut of $750. It goes, they even kind of give some guidelines to a jury. It goes $750, $5,000, $15,000, $30,000. So it's somewhere in there. I mean, so it's, the liability is still going to be there, but you could, I guess, if you truly didn't know, you know, under oath, you didn't know that that software was illegal or not, under oath, you're saying this in front of judge and jury, and they believe you, then you got non-willful penalties. You know, you're still held accountable, but you would have non-willful penalties. Okay, and there is, you know, David Yashar is asking, you know, did they direct it or aware of it? Realistically, it just, you know, I don't. I would just say if they're aware of the infringement occurring. And if they directed that there's more chances to argue in front of a jury of your peers to say they willingly knew, if they were aware of it, well, how much aware of it were they? You know, is this like the New Jersey Bridge? You know, does Governor Christie truly be aware of it, or of his underlings? Was the upper management truly aware? You know, who's aware of it? You know, that comes into play, and it's up to a jury to decide. I suppose, I mean, either one, if there's awareness or direction, either one is sort of willfulness in a sense. But one, I would say, directing, I would say, is almost more willful, at least in my argument, or at least in my opinion, than awareness. But both, you could argue, I'm sure the plaintiff would argue, both are the same, both are willful, so it kind of goes either way. Okay, everybody, it is our end of our discussion. We are having Knowledge Nugget courses. We're building a community. This will be available for membership. We also have our Expert Software Manager course, which is our latest level, and our ESM Pro courses, which are specialty courses as well. If you have any questions, give us a call, send me an email. Thank you guys so much. Any advice in dealing with publishers that have merged or been acquired? Often license changes are implemented. No addendum or license changes are communicated. That's why you know, when it comes to these contracts, if they have language to say, you know, you got to go back in these license agreements, you got to go back and really look at your license agreements. Now, okay, that only applies so far. The question was, any advice in dealing with publishers that have merged or been acquired? So, you know, historically, when Oracle bought PeopleSoft, we're going to find a lot of these cloud products being purchased. You know, Microsoft's going to make plays in the cloud. They could buy Box or Dropbox. You know, we're going to find some interesting mergers, acquisitions coming up. The thing is that a lot of these license agreements have language that says, you know, we have the rights to change our license agreements. And so as long as we state it, you know, on this website, we may or may not notify you via email. You know, it's going to be interesting. So any advice is for those license agreements that you negotiate, try to negotiate it so that if they get acquired, you have a termination clause or have the right to terminate that contract, because you may or may not be like the acquirer, you may not like the support that the acquiring companies applies. Now, for non-negotiated click-through agreements, it gets a little bit more complex. And that is, I would say, try to do your best to keep copies of all license agreements. Go to their website, click a copy of their agreement. Most publishers have it there on their website, or they have per user rights, purchaser use rights, some sort of document at the time of purchase that at least help you make your argument. However, typically they do have that clause that I mentioned. So it becomes more complex, but it does give you something to start with if the acquiring company or the merging company gives you, you know, any riffraff, you know, kind of to go back to that license agreements. License agreements are extraordinarily important, and for those that you negotiate, you really need it. It's not only what you pay. You know, you hear this from all sorts of the greatest negotiators in the world. It's not necessarily what you pay. It doesn't matter if it's software or what the product is. If there's a contract, it's the terms and conditions that go along with that contract. You know, it's not a fair comparison if I buy product X for $15,000 and you buy the same amount of product X for $10,000. You may or may not have gotten a better deal. It depends on the terms and conditions of that contract goes with it. So that applies to, you know, make sure you try to get into the a termination clause if they get acquired. You know, give you some wiggle room there. Thank you guys so much. And for members, hopefully get this recorded. We'll get it up there in some way, shape, or form. Thank you all so much. And that ends the webcast. Mark Diaz, if you would mind staying on.